Some of what Kaushik was speaking about has to do with property, and the presentation I'm going to give now is really focused much more on a different form of property. It's focused on land. So based on my forthcoming book titled Colonial Lives of Property, Law, Land, and Racial Regimes of Ownership, I want here to briefly explore the relationship between race, nation, and property. And I'm going to just make 3 points. The first is that property law and modern racial subjectivities are articulated through and realized in conjunction with one another. The second point is that this articulation appears at different historical conjunctures and in a variety of contexts in different forms, whereby both pre-modern and modern rationales for private property ownership and racial logics that span biological, cultural, and pseudoscientific discourses operate recombinantly to justify the ongoing appropriation of indigenous land in settler colonies. The third point that I want to make is that the co-articulation of modern property law and racial subjectivity is neither arbitrary nor inevitable, and thinking through some recent histories of this formation in different colonial and post-colonial nation-state forms reveals moments of rupture, leading us to the urgent question of how to think and act beyond and outside of private property norms and the ideology of ownership as we currently know these things. Now, in trying to set out in a few minutes how I see modern property law and racial subjectivities as a formation, I explore in the book how this formation really lies at the core of what we can call racial regimes of ownership, so drawing on the work of Cedric Robinson. Now, defining property to begin with is notoriously difficult, particularly when we think about the ever-expanding forms of intellectual property and also the way in which financial markets seemingly enwrap most, if not all, forms of property within their machinations. But here my focus is on real property and land, to be more specific. And I'm also focusing on that form of property that remains hegemonic, which is private property. When we think about state property in colonial contexts, there is an intimate bond between state property and private property ownership in that the latter only materializes on the basis of sovereign colonial claims to underlying or radical title to territory, which in turn lies at the basis of the constitutional legitimacy of the nation state. So that's a very brief way of outlining the relationship between private property ownership, sovereignty, and the nation-state form. There is thus an undeniable relationship between the sovereign assertion of control over territory and the mechanisms through which the state organizes individual property ownership, most notably when it comes to the idea of possession. As Ranajit Guha observed in his classic study, A Rule of Property for Bengal, and I quote, "The English often did speak of the company's territories as an estate. England was thus required to assume the responsibilities of an improving landlord in Bengal." Now, property, understood as relations of ownership, still falls prey to the commonly held idea that private property ownership means having absolute control over a thing. So people often think that this is what ownership means, and progressive property theorists often like to trouble this idea by pointing out to all of the restrictions that exist on the rights of owners, at least in countries with presumed political stability. But if property is not only a matter of economy and control of resources, and is also about the social and political imaginaries that subtend and structure property laws, can concepts such as freedom and security, those most tightly associated with the right to own property, be separated from the colonial and imperial formations that gave birth to them? Has the prevailing and persistent idea that ownership means absolute control over a thing shed its history as primary technique of subjugation over the bodies of black people that facilitated massive amounts of capital accumulation by white plantation owners in the Americas. And if we want to just skip to a contemporary moment, we can consider the issue of policing and counterinsurgency from this perspective. That's not only a matter of dehumanizing an other, but it's a matter of a lethal violence which is premised on a sense of entitlement to control the lives and deaths of other people. Freedom to use property, to alienate it, and to enter into contractual relations on the other side, and on the other side of that coin, security from harm, from deprivation, are both still enmeshed in the racial and colonial legacies of property law formation in settler colonies as elsewhere. And in my view, this is the rot that lies at the core of the legal form of property. It is not just an abstract form emptied out of this very complex and bloody history. But this is not the only problem with the close affiliation between property ownership and security. For Jeremy Bentham, the reason for being of property law was really a way of indemnifying owners from the fear of loss. As Michael Hart and Antonio Negri have argued in their most recent book, Assembly, that fear is the true foundation that lies beneath private property's veneer of security. This is a fear, they write, of hunger, homelessness, subordination, and economic crisis. Now, this fear of loss of security, and here we see the nation state rear its head again, not only pertains to the individual as owner, but also to the individual as part of a racial, ethno-national community which takes citizenship as its juridical form. And here the notion of possessive nationalism can be understood as a corollary of possessive individualism. For the possessive individual, the value of property ownership lies not only in the material power it affords the owner, but also in ownership being posited as the path to full personhood, citizenship, and belonging within the nation state. The psycho-affective dimensions of the possessive individual, including the desire to possess exclusively and to control one's possessions absolutely, to deal with the need for security and to calm the fear of losing one's property, are here transmuted to the stage of the nation state. The possessive individual develops a close identification with national identity. As I explore through the book the rationales for the assertion of colonial sovereignty as well as individual property ownership, each had counterparts in the creation of racial subjectivities. So, for example, the commodity logic of abstraction that underlies modern systems of title registration was first perfected in the settler colony of Australia, so before it then boomeranged back to the UK some 70 years, 60 or 70 years later. So I argue that commodity logic of abstraction that underlies that system of title registration found its counterpart in the abstract figure of the savage based on emerging racial taxonomies that were used to justify colonial settlement on the basis of the terra nullius doctrine. The ideology of improvement, based on English agrarian capitalism, find one of its historical antecedents in Ireland, where William Petty devised a method of measuring the value of land that was contingent upon the value of the labor of the Irish peasantry, a value shaped by their perceived racial, and that combined biological and cultural notions of race based on their racial inferiority. In the late 19th century, early Zionists in Palestine viewed existing modes of cultivation as a reflection of an inferior intellectual capacity of the natives and their less developed culture. So land that required improvement was held by people who themselves required improvement. The Zionist ideology that combined theological and political redemption through a return to the land today remains a bulwark against contemporary legal claims of Bedouin communities seeking the return of their lands from the Israeli state. Now, the sheer heterogeneity contained within articulations of race and property ownership mean that there are, to borrow from Stuart Hall, no guarantees that a given articulation of race and property ownership will appear in the same configuration across time or jurisdictions. And this heterogeneity, in my view, is not only a result of capitalism's cunning ability to continually reproduce itself anew, or it's not due to the plasticity of the legal form itself, but is also occasioned by the resistance, refusal, or negotiation with colonial relations of ownership by First Nations and other racialized subjects. The continual renewal of racial regimes of ownership bears witness both to continually evolving forms of primitive accumulation, as well as the fact that these regimes of ownership are not inevitable, but rather vulnerable to transformation, and I would like to think dismantling. So in terms of the second point, in thinking about the, to borrow from Etienne, interplay of antagonistic strategies that are constantly being renewed as a consequence of their own effects, we see the animating forces of property law reaching for both pre-modern or more archaic rationales for private property ownership in combination with ones that are distinctly modern. This is contrary to the well-established dogma that modern property law is a civilizing force key to a developmental process whereby older justifications for ownership, such as actual possession, are displaced by more rational ones, such as having proof of ownership recorded in a bureaucratic registry. For instance, the very modern form of settler colonial nationalism in Israel was until very recently based on the state holding the land in trust for the Jewish peoples, which in early Zionist literature is conceived of very much as a metaphysical entity, I think. In the context of Jerusalem today, a pure colonial animus to possess the city in its entirety has required the use of a panoply of urban planning, property, and military laws to displace Palestinians, and furthermore, in terms of a nice, interesting contradiction, has actually prevented a rational and modern market in land and real estate from developing. In the settler colony, the desire for possession and the necessity for actual possession of indigenous land recombines with more modern and abstract justifications for ownership. And this is really evident in a lot of indigenous land rights cases, which I won't go into right now. This idea of property logics and racial subjectivities operating recombinantly to affect the same end, dispossession, can also be understood as a reflection of a certain contingency, or at least a non-inevitability of racial regimes of ownership as they are currently configured. And when we think of any emancipatory movement, both historically and in the present, and I'm going to conclude with this, it is incumbent upon us to continually renew that part of our political imaginaries that seek to think beyond and against an ideology of ownership. While the entrepreneurial subject of neoliberalism is an important intervention in terms of thinking about how we understand labor relations and how value is produced, etc., I think the possessive individual also remains very much with us, embedded in an identity property nexus that contaminates most political and social forms that prevail today. So how can the propertied subjects of ownership and accumulation be deposed and depropriated, to borrow a term from Etienne? It may be that the political challenges of this moment require a recalibration and indeed a recentering of how we understand ownership and its relationship to race, gender, class, and nationalism, while we heed the urgent call to abandon what Richard Wright once called the fever of possession. Eva Mackey confronts one of the hallmarks of ownership in the settler colonial context, which is expectation, with an argument for the need to unsettle expectations of certainty, stability, and prosperity that have been built on the dispossession of First Nations. In attempting to depose and depropriate contemporary subjects of ownership who remain embedded in imperial circuits of accumulation, the challenge before us becomes nothing less than a radical unsettling of a social contract based on appropriation and a desire to possess. The creation of types of commoning that break with the legal forms of property as we know them, and the dismantling of sovereign forms of power and subjectivities are, I think, avenues that we must pursue and think about together. Ruthie's notion of abolition geographies, which she spoke about a little bit yesterday, that centers histories of, and I quote, self-organization and world-making activity, present us with a view, an example of how Black people in the South, under Reconstruction, sought to establish a new social order by making the places they were into places they wished to be. She writes, they brought things with them, sensibilities, dependencies, talents, indeed a complement of consciousness and capacity that Cedric Robinson termed an ontological totality. The undoing of bondage, abolition, is quite literally to change places. That's the end of the quote. Through transforming oneself and the place one finds oneself in. So dismantling racial regimes of ownership may begin with recognizing how we are unwittingly caught by the figure of the self-possessive individual in the ways we work, live, and relate to one another, and requires us at a very fundamental level to decommodify our visions of things that we usually expect to own. Thanks.
Thank you, Brenna. I think I have, again, a couple of questions. I'll start with the first one. And I'll start with one statement you make at one point, that these legal regimes, the modern legal regimes, there is no one universal framework to understand this. I was wondering if you'd like to think about these modern legal regimes, particularly with reference to property, in a comparative framework, because this is something I work on the 18th century and early 19th century archive in British India. And I'll briefly discuss this in my presentation as well. Their work on philology was initially started through legal doctrines. When they reached India, they apparently discovered two different types of legal regimes. One they called criminal law, which they also described as Islamic law, and which they accepted. But for the civil law, they apparently discovered different traditions. One they called Hindu law, the other one was the Islamic law. And many of the early legislations, if you look at, from late 18th century onwards, 1772 onwards, they were actually attempts to accommodate these existing legal regimes within the new colonial state. And this is something I was wondering, because this does not apply to the settler colony kind of situation, but would you like to expand on this context specifically? And I have one additional question to this, and then I'll stop. In this kind of encounter with an already existing legal structure and the adaptation of many of them through the colonial state, what is interesting is the way it visibilized the question of gender. If you look at the early legal reformations throughout early part of 19th century, all of them are mostly based on gender, whether it's sati or widow marriage or age of consent. Many of them are coming out through the configuration of gender within these various ideas of property, legal ownership of property, and so on and so forth. Do you see something similar in terms of race, or are they comparable at all, or would you like to say something different?
Sure. Okay. Well, to start with the point about gender, I mean, I think, and I should have said this when I was doing the presentation, but I like the way Avtar Bra actually articulates the relationship between race and gender when she's, in the way that she's developed an intersectional framework, which I think is somewhat broader than some of its American legal lineages. But she writes about how race is always expressed through gender. I mean, and sort of analogously to the way that we are speaking about race as being expressed through class formations or vice versa. So I think when we're talking about race, we are always talking about gender, and when we take property as the focal point through which to think about these formations, I think that becomes very evident. So I can think of many examples in the settler colonial context where the kind of racial formations that I was trying to describe are almost always gendered. So those two things really, when we get into the specifics, can't be sort of disaggregated, I think. Now, turning to the comparative framework that you're you're raising. It's true that in the settler colonial context, because within a colonial racial schema, of course, indigenous populations have been seen as, to borrow from that infamous Privy Council judgment, too low on the scale of civilization to be seen as owners. Many settler colonies have been treated as a legal tabula rasa, which is not the case, of course, in places like India or, in fact, Palestine with the existing Ottoman legal system. And I think what we see actually is the way in which British common law systems, the way in which they interacted with very Orientalist interpretations of what was called customary law, right? And there the question of capitalism comes back in, because of course it was very much, in some cases, a proto-national bourgeoisie who were the ones involved with this system of translation between the British common law and what the British called customary legal forms, some of which you mentioned. Now, one example that comes to mind, which I've done a little bit of research on, has to do with the different form of property, so trusts, and how trust law was brought to colonial Bombay in the late 19th century. And we see there, one of the most, I think, problematic and ultimately kind of devastating legacies of that moment is the imposition of a public-private divide, right, which you mentioned in terms of criminal and civil law. But when it comes to charitable trusts in that context, you see a situation where the British, to oversimplify a bit, British colonial administrators come into a situation where Hindu and Muslim entrepreneurs and the wealthy elite who have money to endow and trust, have a conception of trust that totally defies the British common law idea of what a trust is. And it defies that conception because there is no distinction between a public and private. Property is endowed to support a community of widows. It has maybe a religious connotation. The property is held individually by the family or by a surviving spouse. There's no distinction, as we have in the British common law system, between religious or private charitable functions. And so in that moment we see this imposition of a public-private divide, but with the help of an indigenous bourgeoisie who are also wanting to have their properties validated and recognized as being within a trust form, because of course it's a massive tax-saving. That's the point of creating a trust. So I don't know, maybe that was technical and kind of boring, but that's what happens when you start talking about trust law.
Okay. Do we have time for another question?
Yeah.
Okay. You are also marking a series, right, between property, race, and nation across 19th century, and particularly with reference to settler colonies. I was wondering, how do you respond to the evolving notion of race, particularly after the introduction of scientific racism, let's say in the 19th century, where it is being, notions of phrenology, for instance, or different versions of physiognomy, through which they're trying to ascertain, if you like, the true being of race, that this is where you can actually access the true core of race. How do you respond to that kind of evolving history of race on the one hand, and the relationship that you are posing through this series? Does it complicate that series, or does it allow you to do something else?
I'll try to answer that concisely. So in the idea of thinking about how racial formations and racial regimes of ownership operate recombinantly. I think what I'm trying to get at is how cultural and biological and the pseudoscientific understandings of race do not move from one to the next to the next. In fact, they are all present in different racial formations at different moments. So we see this very clearly with Indigenous rights claims, where Indigenous forms of ownership, when First Nations come to the court to try and prove a land claim, those are defined legally through a very colonial culturalist idea of what it means to be Aboriginal. And it's based on this idea that to be authentically Aboriginal or authentically Indigenous, your cultural practices, never mind the economic practices don't, by definition of needing to show that you are authentically a kind of pre-modern subject, don't even enter into the juridical framework. But you have to show that you have a cultural continuity in your cultural practices that is there from before the time of contact with Europeans. Now, that combines with biological conceptions of race when we think about something like Indian status as it exists in places like Canada and to some degree in the US,
Right.
which are based, even though it's not specifically called a blood quantum rule, Indian status is inherited in a way that reflects a kind of biological, quasi-genealogical conception of race and racial difference. So the cultural and the biological are very present in the same moment when it comes to colonial governance of First Nations land and their access to land, which is based on having Indian status. So I'm not sure if that answers the question, but it...
Can we?
No, you can continue.
Okay. Just to extend this idea further, in order to understand it better, because this is a very new field for me. When you are connecting this with contemporary developments, particularly towards the end of your presentation, do you see further mutation of this, what you are suggesting right now, this idea of race and this scientific racism, or is this a new kind of regime which is setting in, or is there a new kind of idea?
I find it really difficult to call anything new. I don't, maybe I feel like sometimes my disciplinary location as a lawyer is a real limiting factor, because I'm always thinking, well, what is the evidence? What is the evidence for this to be called something new? And I also I'm not sure actually what we gain by focusing on the question of newness or novelty. So I don't know if these racisms are new, but they, I think for me what's more important in trying to diagnose them and to think about how they operate is to be very aware and to be very vigilant that theories of race and racial difference that we think or we thought had disappeared continually reappear in combination with other other conceptualizations of race. So that's why I think it's really important to try and identify where the biological and the cultural and the pseudoscientific are really operating together. They're not, they're not...
What I probably had in mind is, this particularly evocative phrase that you use, racial regimes of ownership. Do you see any change in that regime? I think that was more like the question.
Okay. Yeah, well, I'm just trying to use that as a way of describing a particular formation that I see most poignantly unfolding in settler colonies, but I think that as we were discussing in relationship to other places, I think clearly has resonance in other contexts. Now, we see that formation emerging in the 19th century, and we see it still very much with us today. So, in the settler colonial context, I don't know if that's what's changing within that formation. are the techniques or the strategies that the state has to use to maintain their control over indigenous land. You know, that's where we see kind of new tactics or different techniques developing. And so, you know, we've gone from struggles over the recognition of indigenous title, let's say, to states trying to then capture land that is recognized as being within the governance of First Nations back into a private market, you know. So those are some of the changes that I think we can see.